Good morning, dear colleagues. It's the 16th of January 2023, 10 o'clock in the morning, the start of a new week, and it will be a very exciting week, starting with a highlight from the very beginning. I'm very, very pleased to introduce Professor Dr. Barbara Prainsack to you, who is going to host today's event. Barbara is a professor of political sciences at the University of Vienna, and in particular, and importantly, she is also the head of the platform of the governance of digital practices here at the University of Vienna, which is an interdisciplinary platform uniting scientists with a political science background, a legal background, an STS background, and so on. And we have been working in this platform now for quite some time on some of the issues that we will tackle today. I'm very excited that I have the privilege to be here together with Barbara and Sandra. And I'm handing over now to Barbara, who is going to introduce Professor Sandra Wachter to you.
Thank you very much, Nikolaus, and good morning, everyone from my side as well. Nikolaus kindly mentioned the research platform Governance of Digital Practices, and I think it is no exaggeration to say that Sandra, through her research and also through her very supportive and collegial personality, is a very important person for us in the platform. Those of you who are familiar with the work of the platform, you might know that our work is inspired by Sandra's work, and that Sandra Wachter has also supported us, given a lecture and been on a panel when we did our kickoff event. She has taught at our first winter school, and so on and so on. So for those of you who are not familiar with Sandra, I think there are very few who are not familiar with Professor Sandra Wachter's work. I will highlight a few things. I will not mention everything. I'm now putting the link to her profile in the chat, because Sandra has done so much and her work is being drawn upon and has influenced so many fields of scholarship and practice that I would talk for quite a long time if I gave an overview of all of it. But let me just say what I think is one of her most, among her many outstanding characteristics, what's one of her most outstanding characteristic, that she's really I don't want to use the word disruptive because of the many ways in which the word is used at the moment, but she's really a very, very innovative and original thinker. Her work has influenced and at times really set a new research agendas in the fields of explainable AI, in the field of algorithmic bias, diversity, and fairness. And although Sandra is a legal scholar, as I mentioned earlier, the impact of her work and the influence transcends the field of legal studies and goes into almost any discipline that is concerned with these questions. Sandra is a professor of technology and regulation at the Oxford Internet Institute at the University of Oxford. She has a number of honorary and past affiliations, including with the Berkman Klein Center for Internet and Society at Harvard University. She's also an alumna of the University of Vienna, which the university is also very proud of. And one project in particular I'd like to highlight, which is Sandra's current British Academy project on AI and the right to reasonable algorithmic inferences, where, among many other things, she's doing very, very interesting work on group protection and single-handedly challenging established understandings of what a group is and what kind of group deserves protection from discrimination. So I will hand over to Sandra in a second. Sandra, let me just thank you on behalf of the platform, on behalf of all of us, for being here with us today. And I should also mention that you will speak this evening. You will give a keynote at the University of Vienna in the context of the Semesterfrage, an untranslatable term that could be awkwardly translated as semester question, which is one big question that is kind of a theme for a number of events throughout the semester. And in this case, it's digitization and democracy. So now over to you, Sandra.
Thank you so much for the introduction, Barbara, and for your very kind words. And thank you, Barbara and Nicolaus, for inviting me to come and speak today. It's always a pleasure to be invited back, and yeah, to be able to share some of my research that I'm currently doing. And so I'm going to try to share my slides with you now, and hopefully this will work. We tested it before, so hopefully it should be good. I hope this has worked now.
Yes.
If nobody, yes, perfect. Nobody's screaming. I'm assuming everything's fine. Yes. So the title of my lecture is "When Technology Disrupts the Law." I chose this title on purpose because it kind of summarizes my approach to research, because I'm very much interested in the question of how and if and when new technologies challenge regulation that is already in place. And this is something that I'm not just doing by myself. I'm very lucky to have a research group here at Oxford. We call ourselves the Governance of Emerging Technologies, or GET for short. As you can see, those are the people that I'm working with. It's a very mixed group. There are a couple of lawyers. We have ethicists, computer scientists, people from political science and psychology. So the interdisciplinary nature is really, really important to me as a researcher, because I actually think we need as many different brains as possible to tackle those novel problems together. And we are very much interested in that question. What can we do in order to create new governance mechanisms that make sure that we harness the good that emerging technologies can do, but make sure that we are not harming human rights unnecessary. So if you're interested in the work that the group and I are doing, you can look at a webpage here at the Oxford Internet Institute and get a sense of what the things are that keep us up at night. So roughly the way that we approach this is that we get interested in a particular technology. We call ourselves GET because we are interested in emergent technology. So any type of technology is very interesting to us. We are at the moment working very strongly and heavily on questions of algorithmic accountability. And so I'm going to talk about those projects in more detail. But in reality, we are very interested in anything that has to do with new tech. So this might be fake news or deep fake, so platform regulation, robotics, you name it. Anything tech related is something that is really close to our heart. But at the moment, AI is something that dominates our research agenda. And so the way that we do this, and the way how I think about research and how, like, my method, if you will, is that I get fascinated or frightened or both by a new technology, and I see potential harms. And then I'm usually asking the question, well, is this really a new harm or a new opportunity? And is there something that the law already has in place to deal with this issue? Very often, and that's a lot of the research that I'm doing, is to show that the questions that we're now dealing with are fundamentally different than the ones that we used to have. And so the law is not well equipped to deal with that issue. And I'm going to talk about a couple of examples here in more detail. Then the next step is then to think about the normative and ethical side of things. So if the law doesn't have an answer, what would it be from the normative side of things that we would like to see? What would an ethical good framework actually look like if we were able to design that? And then we usually also think about solutions. So it's not just about trying to show the issues that are arising, but really thinking about solutions here. And this is where the computer scientists often help us, and we try to figure out whether there is some piece of technology that can help us with the current conundrum. And so what we are working on at the moment in terms of algorithmic governance has to do with explainability, data protection and data inference, and bias and discrimination. So the question is, why those three topics? Why are those three topics that keep us up at night? And I think it has to do with the technology and how it works, and just the fears of our lives that they're touching. So just 3 examples here that show you where algorithms are currently used and how they are potentially harmful for our society. So we know, for example, that insurance companies tend to use or starting to use untraditional data sources when they want to make decisions, for example, about insurance. So rather than using traditional forms of data, they're interested in your online presence. So that means the friends that you have on Facebook, the groups that you join, the things that you post. And so this is actually what privacy in way to evaluate whether or not you should be granted insurance. We also see that algorithms and face recognition software in particular are now being used to make job decisions, whether you should get hired, whether you should be invited to a job interview, things like that. So again, moving away from traditional data sources like a resume, a CV, reference letters, algorithms are now interested like how you move your face and your gestures, the pitch of your voice, and those kind of things are all of a sudden factors in making decisions on whether you should be successful in the job market. And face recognition software is also, for example, used to decide whether you should get a loan. Again, very untraditional things. Traditionally, we would look at savings or income, things like that, to decide if somebody is likely to default on a loan. And now we are using untraditional data sources such as face recognition software to make that decision. And like, if you think about those three examples that I just mentioned, three distinct, related but distinct issues come up. One has to do with privacy, one with bias, and one is the black box problem. The privacy issue with all of those is very, very clear because we are talking about predictions. So with all of those examples, we are thinking about the future in a way, where we're trying to predict if somebody's going to be a reliable borrower. We're trying to think about whether somebody might get sick in the future. We're trying to think if somebody's going to be a good employer. And so this is predictions, but they're also in a way like personal data in a sense, but because it's information about you. And so even though you could say, well, this is unfortunate because we're using mass data to decide whether you should get any of those benefits, you could say, well, isn't there a law already in place, like data protection law, that could help to make sure that decisions are made in a way that is acceptable? And this is, again, the first step, how we started to think about this issue as well. And we started to look at data protection law to figure out whether or not, we can fall back on the law to help us make sure that algorithms are, acting in our best interest, if you will. And so we wrote a paper that is called A Right to Reasonable Inferences, Rethinking Data Protection Law in Big Data and AI. And so this was the first piece where we, again, if you think about the three steps that we usually do, thinking about whether the law is good enough, this was the paper to show that it is not good enough. And so we were very disappointed by that, because we were hoping that the law would actually give us enough protection to govern this new age of algorithms and AI. So the question that we asked ourselves, what are those inferences, right? Those inferences and predictions, being a good worker, not defaulting on a loan, being somebody that's not going to get sick, whether this is personal data, because we were interested in this, because if it is personal data, all the data protection rights would open up for you. And if they are inferences, then you would have a bunch of very important rights at your disposal. For example, the right of access. I could go and ask what kind of information is available about me, what kind of inferences are being made about me. And I could also go back and ask for this information to be rectified. I could say, well, I don't think you have assessed me accurately. In fact, I'm a good worker, or I'm likely to repay my loan, or I am somebody that is likely not going to get sick. And so what we found is that the data protection law, interestingly, treats inferences somewhat differently than other pieces of data. And in fact, the Court of Justice is not even fully sure whether inferences should count as personal data. There's some instances where the court said, yes, it is personal data. Some instances where the court said it is not. Most importantly, it didn't really matter whether or not inferences should be categorized as personal data, because what the court really clearly said is that the remit of data protection law is not to regulate decision-making. It's not there to make sure that you have fair and transparent decisions. It's procedural privacy. It's not about giving people recourse over how they're being assessed. If you want a recourse, then you have to find a sectoral law that allows you to do so. The only thing that data protection law is really concerned with is things like, notice and consent, making sure that you understand how your data is being used, the procedural side of it, but not the content side of it. And I found that was really surprising in a way, because I thought that data protection law has a broader remit than that. And that is really problematic, because if data protection law doesn't give you any help in navigating how you're being assessed, and you need a sectorial law, I do have bad news for you, because we don't actually have that many sectorial laws that govern decision making, because we don't necessarily have a right to get a job or insurance or a loan or attend university. Very often there is private autonomy that prevails, and so people can just make decisions as they please, and you don't have any recourse. And that means that even though big data is being used in a wide range of cases, and you're being assessed according to those, you actually have no real overview over how you're being assessed. So this is the privacy component that I'm currently working on, but I'm very unhappy with the way that the law is governing it, because I think that technology has evolved since we last thought about data protection in a sense. Related to this issue of privacy is obviously the question of fairness. Like, if you amass such large amounts of data, then it is, of course, troubling. One of the reasons why it's troubling is because it could lead to discrimination. And so 2 examples here, one from my home in Austria, where we saw that this is already happening. So like the Austrian Employment Agency had a scandal a couple of years back, where they used an algorithm to decide who should get and what kind of unemployment benefits people should get. And what happened is that the algorithm was discriminating against older citizens and people living with disabilities. In my adopted home, we saw a similar issue where an algorithm was used to decide if somebody should be admitted to university. And what happened is that the algorithm started to discriminate against people, students of color, for example. So we can see that algorithms are starting to hurt communities in our society that are already disadvantaged. And one of the reasons is definitely because there's so much data about them available. But again, the first issue that you need to do is to think about whether or not the law doesn't help you already, or whether the law can already help you in a way, because discrimination is not something that is new. Discrimination has been unfortunately around since humans existed. So why not just go to non-discrimination law and ask non-discrimination law for help? And again, this is the first step that we did in that research project, together with Brent Middlestead, who is an ethicist, and Chris Russell, who is in machine learning, and I'm the lawyer on that paper. And so the paper is called "Why Fairness Cannot Be Automated: Bridging the Gap Between EU Non-Discrimination Law and AI." And you can see in the title, as this often happens with my work, I don't think that non-discrimination law will be good enough to guard against those risks. And one of the reasons is, again, because the law was written in a way that anticipated a different type of perpetrator, not an algorithmic perpetrator, but a human perpetrator. And so the frameworks that we have in place are just not good enough to deal with that. And so to justify that claim a little bit, let me just briefly tell you the 2 very basics about non-discrimination law, and then I'm going to tell you how technology is completely disrupting the structure. So in Europe, we have non-discrimination law that prohibits so-called direct and indirect discrimination. So direct discrimination means that I should not treat somebody less favorably based on a protected attribute that they possess. So I'm not supposed to say, I'm not giving you the job because you're Black or because you're a woman. In most cases, this will be illegal. And indirect discrimination is also prohibited. This is when somebody is applying a neutral provision, criterion, or practice to everybody equally, and it just so happens that it poses a particular disadvantage on a specific group when compared with others in a similar situation. So that means that if I'm saying I'm only going to hire people that are taller than 2 meters, then height is not a protected attribute. It's a neutral criterion that is applied to everybody equally, but you will immediately understand, if you use height as a hiring requirement, that this will disadvantage, for example, women. And so this is basically how non-discrimination law operates. And we asked ourselves the question, why not just transport this idea, this mechanism, and apply it onto algorithms? And so the reason why I don't think this is working is because, as I said, algorithms just discriminate in a different way than humans. They're much more subtle and intangible, and their harm is less easy to detect. And so I have 3 reasons here why non-discrimination law is disrupted if algorithms are the discriminators. One has to do that the claimants don't necessarily feel that they're discriminated against. One has to do that there is potentially a big lack of evidence to prove your case. And the third has to do that sometimes algorithms group you in a way and discriminate you based on that grouping, but this grouping is not protected under non-discrimination law. So let's talk about the first one. What do I mean with not feeling discriminated against? So it makes sense that non-discrimination law is a so-called complaint-based system. That means I feel that something is harmful, somebody's trying to do something harmful to me. Somebody else is being promoted over my head. I'm being harassed. I feel injustice. I feel this injustice. And then I go and bring a complaint. So algorithms do this in a different way. They actually do this behind our back without us being aware. The most prominent example here is, for example, Facebook, where Facebook was able to infer users' ethnicity without them being aware of it. And then they let advertisers use that information to exclude them from seeing certain opportunities. So advertisers were able to exclude people based on race from seeing job advertisement for housing, and advertisements for financial services. But of course, the users didn't know about that. They didn't know that their race was being inferred, and they didn't know that they missed out on opportunities. They were looking for a job, and everything that they found is this. And so a complaint-based system cannot help a person that doesn't know that they have been harmed. So that's one of the first reasons why the law is being disrupted by AI in that sense. The second one has to do with the fact that there is less evidence to actually prove your case. If you remember the example that I gave you where I said, if somebody was to hire only very tall people, you did immediately understand why this is a problem and how height correlates with sex, potentially gender. And so this is exactly how judges do this too, right? They use their intuition, they use their common knowledge and facts and their convictions to understand whether something is fair or not. It's real life cases. You understand how humans operate, you understand their motivations, and the social inequalities therefore immediately apparent. So from the case law, again, to examples that show that that type of thinking is exactly what judges usually do, is, for example, a ban on headscarf. Let's just imagine an employer was to say, I will ban headscarves forever from the workplace. Headscarves is not a protected attribute, but you will immediately understand that this is in conflict with free religion. And similarly, if an employer was to say they're only giving out social benefits to married couples, you will understand this could be in conflict with protections against discrimination based on sexuality. Again, because you have a social gut that understands the social reality, the motivations, and how the world functions. With AI, this whole thing is a little bit different because I said AI is using so many untraditional data sources where the social inequality is not immediately apparent. Like, because if I use your Netflix viewing habits, is that problematic? It might be off, but is it problematic in the same way that a headscarf ban would be? Probably not. Or if it is, I don't have the evidence to back it up. I cannot really show that my viewing habits correlate with ethnicity, gender, sexual orientation. What if I have a dog and dog ownership is all of a sudden something that is being used to make important decisions about people? Again, might be odd, but might not be something that immediately makes your alarm bells ring. Or what if I'm asking you during a job interview what your favorite color is? Do you think that's odd or problematic, should be illegal? Maybe, maybe not, but it definitely is not the same as a headscarf ban. But the danger here is that a proxy was created that nobody, including the claimant, was aware. So I'm using the favorite color example because there was research that was done, pseudo-research, I should say, pseudo-research that was done in the 19th century where people, scientists were claiming that your favorite color could be an indication of what your sexual orientation is. So the research suggested that if you like the color green or red, you're more likely to be gay. Again, debunked research, nonsense research, completely disproven, but there was a point in time where people believed that color correlates with sexuality. Well, that's what algorithms are really good at. They're very good at finding correlations between data points that don't necessarily make a lot of sense together or that you would associate with each other, but nonetheless could function as a proxy. So an algorithm could find a correlation between liking the color green and being gay, and all of a sudden you're asked doing a job interview if you like the color green, and you might say yes, and you outed yourself without actually being aware of it. So this is the second reason why non-discrimination law is being disrupted. And the third one has to do with the groups. So we talked a lot about discrimination based on sex and gender and sexual orientation, ethnicity, but algorithms group you differently, very often differently, because again, those groups are based on what humans think is interesting or special about people. We categorize people according to their skin color, to their sexual orientation, to their gender. We think this is an interesting criterion to group people for some reason. We can dispute whether this is actually a good idea, but this is what humans do. Algorithms group you in a different way, in a way that humans would not necessarily think to group people. So they might group you as a dog owner, and they think this is interesting. They might group you as somebody that is a sad teenager, or a gambler, or somebody that is a single parent, and they use this information to make important decisions about you. They might make decisions on, whether you should get a loan or insurance, or whether you should be allowed to go to university, maybe show you certain advertisements. And you could say, well, like, who cares? Like, obviously, single parents or gamblers, let them categorize like that. What could be the issue here? And so I would caution against this, because we can see a trend that those untraditional groups are very often used for life-changing decisions. So if you are applying for a job at some point, let me give you some piece of advice. If you apply for a job, then please submit your online application using Firefox and Chrome, and not Internet Explorer or Safari, because your chances are higher to get the job if you use Chrome or Firefox. So people are being discriminated against based on their browser choices. And if you ever want to apply for an online loan, you should make sure that you are only using lower letters and capital letters, and not all caps or all lower letters. If you use only caps and lower letters, then you're more likely to get rejected. So again, this is new. This is not something that the law anticipates. Traditional protected groups are based on ethnicity, sexual orientation, ability, age, but nobody thought about protecting Internet Explorer users or people that only use lower caps when they're typing. And so you can see that the law is being disrupted here because new groups are being used to make very important decisions. And again, that leads me now to the last one, the last piece of research, or the last area of research that we're doing in this space. And this has to do with the black box problem. And this, again, starting with the privacy issue, a lot of data is being collected about you. You might be discriminated based on that. You apply for a loan or a job, and the thing that you get back is a rejection. And that's all you get. And you're never going to find out why and how you have been rejected for whatever you were after. And again, what's your gut reaction to this? Well, first of all, that's unfair. And second of all, I want to know why. And so we were very interested in this question as well. I think it's a fundamentally important question, especially for important decisions. And so we consulted the law to figure out whether there is a right to explanation, which is something that, in my opinion, should be granted if important decisions are being made about you. And so we wrote a paper where the title is "Why a Right to Explanation Does Not Exist." Again, I think it's the shortest summary of a paper that I ever had. Just have to look at the title and you know what the paper is about. It's an analysis of the GDPR showing that unfortunately there is not enough to back up a so-called right to explanation. So you don't necessarily have a right that anything is being explained to you. But yeah, so this is the stuff that we have been doing on the normative side of things. We are, as I said, very interested also in the solution side of things, because it's very easy to burn down a house. It's much harder to build it up again. And so we are also thinking in directions of solutions. And so with all of those three areas, privacy, black boxes, and biases, we have tried to come up with ideas, or at least start a conversation of how we can improve the current legal situation. To come back to the privacy issue that I see, I mentioned at the beginning that I don't think that GDPR, or in fact any data protection framework, adequately regulates the use of inferred data. And I think that's a problem, because this is where the gold is. This is what the algorithms are after. They're not necessarily interested in the input data. They're interested in what they can learn from that data. And so my current research project is called The Right to Reasonable Inferences, where I try to change how we think about data protection law. So what I'm quite annoyed with is that at the moment, everything is focused on consent and notice and consent. And whenever you open up an app or your laptop, something is being flagged in your face and you have to consent to it without having any other options. And actually, nobody has the time to read the terms and conditions. And I think that's disrespectful. I don't understand why I have to protect and defend one of my human rights 700 times a day. This should not be the case. And so rather than constantly burdening people with defending their rights, I would like to see something that looks at the justification side of things. So those who want the data, right, big tech companies, for example, they will need to show and they need to justify why they need that data and why it is necessary for their purposes. And so trying to figure out, I want to see a world where I can use the technology without having to worry all the time. Just imagine it was a plane, right? And every time you go on a plane, you have to fear whether it's crashing or not. No, good legal practice means that I don't have to defend my right on a daily basis. And so I want to make sure that those who collect in the data are following the guidelines and I can trust. And I want to make sure that we have abilities to contest how we're being seen. If you're all of a sudden using facial recognition software to assess whether I should get a loan, should get a job, sure as hell I should have some insight into what kind of methods are being used and what your sources are and whether science actually backs up your claims. And if it doesn't, I should have an ability to defend myself and make my case. So I want to create a dialogue between those who are being assessed and the assessors. And so this reinvention or reimagining of that law has had actually positive feedback over the last couple of years. So the World Economic Forum has cited our ideas in recent reports. The same has happened on the level of the European Parliament, where a couple of reports were published that were citing our work. And here, my adopted home, this is also being done. We're currently framing new data protection laws because, as you know, we left the European Union. And so some of the ideas that I have developed are now in consultation and hopefully will lead to better protection further down the line. Then black box, as I said, that was the second problem. If all of a sudden algorithms are making decisions about you and you don't understand how and why and when they're being made, I believe you should have a right that this is being explained to you in a way. And so I always thought that's a reasonable request. Who could have a problem with that? Turns out a lot of people do have a problem with that, which I didn't anticipate. And so in my quest on trying to do something to open up the black box in a reasonable way, those were the top 4 reasons that were thrown in my face as to why transparency is not the way forward. And so people were saying, well, I don't want to disclose how my algorithms work because this might infringe trade secrets and intellectual property rights or the privacy of other people. I don't want transparency. Other people said, well, it's technically impossible. You can't actually explain an algorithm. This is wishful thinking. The tech's not there yet. It's not possible. Others were more optimistic and they say, well, there is a way to explain some of it, but it won't be meaningful for the person that is applying to the job, to the loan, or anything like that. And the fourth camp was saying transparency is a nuisance because manipulation and gaming could lead, too much transparency could lead to manipulation and gaming of the system. And I guess, yes, all of those, those arguments have some clout, and I appreciate that many of those things are absolutely true. But I just don't think that's good enough. Like, we can't have a black box society just because it is inconvenient to be more transparent. And so we use those concerns as a to-do list, if you will, to think about explainability in a more in a deeper way. And we wrote a paper that's called Counterfactual Explanations, Opening the Black Box of Automated Decisions. And again, with Brent Middlestead and Chris Russell. So the 3 of us stuck together, and we tried to figure out if there's anything that we could do. And there is. So whenever a person tells you something is not possible, you should prove them wrong. And so this was our attempt to do that. And we were able to create a new mathematical method to actually explain how and why an algorithm is making a decision about you. So just one example how this works, it's actually, again, a combination of philosophy and law and computer science. And Brent Middlestead and we laid the foundational normative framework, and then Chris Russell turned this into code, if you will. And so what you can do now is that if you wanted to have an explanation of how a decision was made, you could compute a so-called counterfactual explanation that tells you why this decision was made. In a loan setting, this would, for example, mean, you apply for a loan, you didn't get it, and the code would spit you this type of information back. It would tell you, you have been denied a loan because your income was 30,000 K. If it had been 45,000 K, we would have offered you the loan. And this type of information helps you in various ways. It helps you understand why this decision was made. It could help you to challenge it in case you think that the algorithm got it wrong, you actually have higher income, and it could help you to make future decisions. And with this particular research, we were actually able to take on board all of those concerns that we heard why people didn't want to be transparent. And so with counterfactual explanations, it's possible to understand how a decision was made without having to understand the internal logic of the algorithm. So as I said, many people said that it's not possible to explain anything. And if it is possible, it's not meaningful. And so our method does exactly that. It is possible to understand it, even though you're dealing with complex models, and they're easy to understand. So that was a purposeful decision. So that type of excuse has no clout anymore. And because we're only giving out limited information, and not everything about the code, it's also less likely to infringe on rights and freedoms of others. So it's minimal information, and so less likely to infringe on AP and trade secrets rights, which again is very important. But at the same time, give enough information for people to go away and learn something from it, or have some understanding. And because you're only giving out limited information, it's also less likely that you can manipulate or game the system. And so because we did this, and I think because the 3 of us really worked together, I don't think one of us would have been able to do this by themselves. I think this particular piece of work has been quite impactful. So the method that we have developed is now being used by Google in Google Cloud and TensorFlow. It's being used by IBM Research. It's used by Flock, which is a drone insurance company, and it's used by Vodafone, among many other tech companies or industry partners that have done that felt that what we have done is interesting. So it's really, really great to see that you cook something up in the ivory tower, and at some point somebody from industry stumbles across your work and thinks this is useful, which is really great to see. But the work that we have been doing is also very important for policymakers in that sense. So we had, for example, people from the Article 29 Working Party citing some of the work that we have been doing, and the European Commission did that as well. And so let me come to the last point, which was the work that we have been doing on fairness. And as I said, there are so many awful experiences that we already have in our society where algorithms start to discriminate against us without us being aware, and they are responsible for further entrenchment of groups that are already disadvantaged in our society. And again, this is not something that is particularly new. This is something that a lot of researchers are thankfully aware of, and one of the reasons why a lot of research focuses on so-called bias tests. And so that means that you try to use a piece of code to detect on whether or not your algorithm is biased. And you need to do this because algorithms are using so much data, and so you wouldn't be able to detect this just with the naked eye. And so what we did is, again, we looked at all those bias tests that are currently out there in our paper, Bias Preservation in Machine Learning, the Legality of Fairness Metrics under EU Non-Discrimination Law. And so we were interested in whether or not those bias tests that are currently being used actually live up to the standards that we have in the European Union, and whether they are compatible and compliant with what the European law foresees for us. And so we looked at the 20 most common bias tests that are being used to detect whether something is fair or not on a tech basis. And we came to the conclusion that out of those 20, 13 do not. So 2/3 out of those tests do actually not live up to the standards of European non-discrimination law, which was quite shocking for us. We didn't expect that. I think one of the reasons why this is the case is because the majority of tests, if not all, were developed in the US, where fairness and transparency and equality and discrimination mean very different things that they do in Europe. It's just a completely different system. So what might be fair in the US is potentially illegal in Europe, and vice versa. And so because of this, we stuck our heads together as well and tried to do something about this, and wrote the paper, which is called Why Fairness Cannot Be Automated, where we tried to think about whether a so-called European test would be possible. So we tried to, again, with normative people, myself and Brent, and then looking over to Chris, who writes the code, where we tried to sketch out for him what fairness means in Europe, and then worked with him to figure out whether there is a technical test that we could create that lives up for that and tests according to the standards of European non-discrimination law. And we did. And so this is the test that is called conditional demographic disparity, that we developed purposefully to test for bias and fairness under what non-discrimination law in Europe thinks is bias and fairness. And again, this was also very exciting because policymakers around the world took notice of our work here. So the Center of Data Ethics here in my adopted home published a couple of reports praising and citing that work. Same has happened at the World Economic Forum. The European Commission and Parliament published a couple of reports, and I know that the current AI Act that is being drafted is impacted by some of the research that we have been doing here on bias. And lastly, Amazon came across our work, I think a year ago or so, just stumbled across our work like all the other industry people, and just felt that this test could be useful for the purposes as well. And so they are using it now too in SageMaker Clarify, which is a bias toolkit that is available for all Amazon Web Services users, which is super exciting to see. So anybody who wants to test whether their algorithm is compliant with European law can do this now using that toolkit. But again, as I said, Everything that we do, this is true for the explanations as well as for the bias test, everything is open access, open data. So anybody can use it if they wanted to. The little startup across the street can use it just as much as any tech giant. That was really important to us, that we just put something out there for everybody, and hopefully it will be useful for some people. So yeah, let me stop here and just capture one more time what the things are that keep me up at night at the moment when it comes to algorithmic accountability. As I said, I think there's a privacy issue, because there's always one when there's data involved, and I'm trying to create new standards to make sure that privacy is protected in a way that is commended with what is expected of our society at the moment. And so I'm fighting for a right to reasonable inferences. I'm fighting also for explanations, because I think the black box problem is something that we need to get a hold of, because it's important that people really understand how and why decisions are being made about them. And those fairness tests and bias tests that I mentioned, I hope that those will help to make algorithms more accountable. So yeah, this is a quick, not so quick, I guess, overview of the things that keep me up at night, and that I hope will be interesting for you. And I very much look forward to for a discussion with you all. Thank you.
Thank you very much, Sandra. So anyone who would like to ask a question or add a comment, please do so. You can do that in the comment box, and we will see it and read it to Sandra. So while we are waiting for our colleagues to come in, Sandra, I think there's nothing to add to the wonderful way in which you have described how digitization and artificial intelligence in particular are challenging some of the legal instruments that our societies are operating with. To zoom in on one, the fact that when algorithms make decisions, quote unquote, as you explained, very often the people who are negatively affected by this don't even know about that. So this is very much a problem that we are also working on, and I'll flag up at this point the work that we're doing in the platform on data solidarity and the need for better harm mitigation instruments that address the very same problem. But one of the the comments that I receive very often when in our own work is that people say, well, you know, maybe algorithms aren't so different after all, because it's true that people don't always know on what basis the decisions are made, but such is real life, right? So there's tacit knowledge, people discriminate against each other on the basis of all kinds of things that we might not know about. So recently somebody told me that she would never want to give a job to someone who asks others to take their shoes off in their flat because it indicates that they are from a bad home, you know? So there are all kinds of tacit rules. So how do you respond to that kind of comment? Where do you say that algorithms are treated differently beyond the fact that, of course, a human being can be asked to explain themselves and an algorithm cannot? So you've developed wonderful tools to help us do that. But how do you respond to this comment that maybe we are in an unjustified way treating machine decisions different from human decisions?
Yes, so I love that question. It's one of the questions that I also get asked a lot, and I think there's a short and a longer answer. So I'm gonna try the short one. I think you can, like, on a meta level, you can see this as a philosophical question. It's the main question is, why the hell are you even doing this? Like, why do we care about tech? What's the purpose of innovation? And like, in a very binary way, you can be part of one of two camps. You can say, oh, you know, technology is there for efficiency gains, to make decisions faster, to make them less time and cost intensive, and we're just going to automate whatever humans have been doing, so we can cut costs, right? And that's a legitimate way to think about innovation, I guess. And then, yes, then it's fine. Then you have a racist, sexist, ableist algorithm that is doing the same horrendous things that humans have been doing, because your goal, your compass, your purpose was always just to automate and make it quicker and faster, make human decision making faster. So that's the one camp. I'm sitting in the other camp. For me, innovation is useless if it doesn't improve the lives of people.
Yeah.
And so for me, innovation always has been something that is supposed to be a bridge, be something that brings us closer, that improves the lives of people, makes them healthier, makes them stronger, makes them happier. And so if you have technology that is just as bad as humans, then I don't think you have done your work yet. And so if we are all so excited about AI, I'm excited about AI because it has potential to make better decisions, like less biased ones, ones that are more explainable, because who understands what's going on in a human's head? And so for me, that's the guiding star. And so if you are the philosopher that thinks innovation should help society, then you can dismiss the argument of those who say that algorithms are not problematic because they're just as bad as humans. If that makes sense.
Yeah, that makes a lot of sense. And also, I think what's often forgotten in these discussions is what Theodore Porter called mechanical objectivity, right? That humans tend to trust machines more than they trust other humans.
Yeah.
We have one. Sorry, Nicolas, did you want to add something to this?
No, I'm just bringing in the question, and I also have a question, and if time allows, but please go ahead with, if I may suggest that, with Paul's question. Mm-hmm.
Yeah, so Paul, who's one of our colleagues at the platform, is asking, with regard to counterfactual explanation, how do you decide which information variables to include in the explanation and which ones to leave out? Who makes this decision?
Yeah, excellent question. It's an excellent question that the team and I have been grappling with for quite some time. And I think it's a really important question, because just because the idea is neat in terms of that it allows you to understand what the most important factors are, there's still, selection bias. So the good thing about counterfactuals is that they will present to you the most important criteria, like the ones that actually had an impact on the decision. So they wouldn't bother you with criteria that wouldn't really swing the decision one way or the other. So let's say that, the fact whether you have black shoes factored in there, but it wouldn't have made it different if it had been white, this information will not be shown to you. So that's the method that in itself makes it neat and somewhat limits the scope of what's being shown to people. Yet, and I think this is what your question comes to, is that there might be 3 factors that are roughly equal in weight. And so then you are in a situation where, which one of those 3 do you choose? And so, if you want to be cynical about this, there might be some reasons that look beneficial to the decision maker and those that do not. So if you don't get a job, it might be because your reference letters were bad, because you had typos in your CV, and because you're black. And all of those might be equal, but I'm only going to tell you about 2 of them, right? But you're most interested probably in the fact that somebody didn't give you the job because you're black. And so that's a really important point, because we want to make sure that we get genuine explanation, that we're not just cherry picking the ones that make us look good. And so we are doing research in that regard, because we want to do this from 2 angles. The one is to figure out, to your first question, who gets to decide what's useful. We are doing case studies and focus groups to figure out what people actually think is useful. Because I can come up with ideas, but it's probably most useful to ask the people that are applying for jobs what kind of information is useful for them. So we're doing some qualitative work to figure out what information will be useful for that. But in addition to that, you need an oversight mechanism. So you make sure that the people are not just cherry picking what they are showing to the users. And so we are working on an auditing tool that lets you figure out whether or not the counterfactual explanation is telling you the truth. So it's an algorithm watching the algorithm. And so, yeah, if you're interested in this, so Chris Russell has written some code on that, if you're interested in looking into this a bit further.
Nikolaus. Thank you, Sandra.
Yeah.
Nikolaus.
Thank you so much. Just one very short question, Sandra, if I may. I mean, so much of what you're doing is so highly interesting from a very fundamental perspective on how to look into AI and privacy and so on. However, not too much of this is to be seen in my view, at least, in the precise text coming out of what the European Commission is doing. And there, in my view, there is some kind of a disconnection between the fundamental research people like you and others are doing, and what the outcome of this is then in the day-to-day political practice and the day-to-day legal texts coming out of the European Commission's preparatory work. And my question there would be whether you see any instrument, and if so, which one, to connect those two parts better than at the moment. And perhaps a follow-up question of this: what precisely is the role of an academic in this? Is it to do the groundbreaking work, hoping that people read this and stumble across it and follow it, or is it more doing the critical commentary work after having read what the legislator has made out of this, or is it both? And how to outbalance it properly?
Yeah, I mean, that's also a very good question, and something that I'm struggling with myself. Again, it's probably a philosophical question of what do you see? What's the point of science and research? Is it about just doing what you think is interesting without thinking about the outside world, or is research always in service of something else? And in my opinion, it's really important to find a healthy middle ground. I think it's very, very dangerous if science and academia are being tempted to only do research as a service, if you will, that you only, figuring out the questions because this is what politics says at the moment is important. Like a lot of the things that society has benefited from was blue sky research. There was just people because they just wanted to know, just imagine Newton would have cared about what the European Union said, right? It's really about figuring out interesting things. But of course, if you just do that, and if you just in your ivory tower and you don't really care about what other about the rest of society, there's a lot of interesting knowledge that might be just lost, in the sense that other disciplines could benefit from it. It could just enlighten society as a whole, and it could maybe at some point have impact on politics. And so I think, the topic that you choose, in my opinion, should always be one that is curiosity driven. At least that's how I do it. For me, blue sky research is really, really important, because I just want an answer to that question, regardless of who hears that answer. But I also think there's a responsibility of science not to be too elitist and just keep the knowledge to themselves. And so I think having there's some type of responsibility to just engage with students, engage with people that are interested, having conferences and roundtables, talk to media, because it is just enriching for everybody to learn more about this. And this is just how I see science and academia trying to find a healthy middle ground. And in relation to what politics are doing, it's always a little bit of a disconnect between what politics are doing and what science and research are doing. I think the best you can do is just offer your services to those who are interested in it, right? And keep on trying to engage with policymakers if they want information on, the current state of regulation, and offer some guidance and ideas for that. And I think that's the best that one can do, I think, and hoping that some of that will be useful for either students, for the media, for politics, or for industry.
Thank you.
So let me reiterate the invitation for our colleagues to ask another question. We've got time for one final one. I also have one, Sandra, and what you said about blue sky thinking, yet having in mind the sort of real world relevance of that. I think brings me to another issue that is quite a radical step away, I think, from current data governance frameworks. So many of the data governance frameworks at the moment focus on data once they're there, right? So how do we use data to whose benefits and so on and so on. What about the idea that is being put forward by colleagues who come from the indigenous data sovereignty field and other critical perspectives who say that maybe there should be a right to non-datafication. So at a time when, at an era when we can link data sets, when de-identification is very often possible, when privacy is changing its face in many contexts, should there be parts of our lives, our bodies, our behaviors that we as citizens have a right to not be datafied? So let's not even record what we do. Yeah. So what's your view on that?
Yeah, my heart starts beating faster when I hear that. In the right to reasonable inferences, if I had to summarize that piece, it would be, you have a right over how you're being seen. But I think the counterpart to that is that you should also have a right not to be seen and to be private. And so again, coming back to Nicola's question of like the disconnect between what academia does and what law is doing, brings it very, very back to your question now, because data protection framework, as you rightly say, that deals with the data that is already there. And it's about data management, it's about consent, it's about notice, it's about impact assessment. You know, it's a very procedural thing. But there's none of that discussion in GDPR actually talks about why privacy is important and why privacy should be protected and what kind of value it actually brings to society. It's really just data focused, but like, who cares if data is private? You care about the person whose data it is. And so why is data protection really important to people? And so I much rather like the case law of the European Court of Human Rights, because they have a much more impactful and flowery language that is almost poetic in a sense, because that really understands why privacy is important. And privacy is important because, you know, you have a right over how you're being seen and over your reputation. You have a right to forge relationships with people, but you also have the right to retreat, a right to have a sacred home that is only yours, have a sacred space where you can let your hair down and just be yourself and develop your own thoughts and ideas. And so that's really important, but again, something that is completely lost in the current data protection regulation, because as you said, we only deal with the thing that is already there. We don't actually ask the question if that thing should be there to begin with. And so I like this idea. I would love to see more of that you should have a right not to be seen and be left alone. And I think there's a promising avenue here, because like you can see roots already in the right to be forgotten, right? That is definitely a counter mechanism where the law said you have a right to reinvent yourself at some point, and just some of your past mistakes or things that you no longer want to see present need to leave the stage in order for you to become a new person. So why shouldn't you have also the ability to just be left alone and not having to share all your data, or have a right that data is not created about you? I think it's a beautiful idea, and I would love to see more of that, because it really comes back to why privacy is so important for not just a human being and their personal development, but also for society as a whole.
I think that's a very beautiful final comment, unless Nikolaus, you have another question. No. Otherwise, I will thank Sandra already on my behalf, and I hand over to Nikolaus with my thanks also for making this format possible, for hosting the discussion today. And over to you, Nikolaus.
You're muted still.
Absolutely. It's a tool, not a bug. Yeah. Thank you so much, Sandra. Thank you so much, Barbara. It was very, very fascinating to have you here, and a huge privilege to have you here. Just one last hint for those in Vienna: if you want to listen to Sandra again today, there is another opportunity today on Monday, the 16th of January 2023 at 6 p.m. in the big hall of the University of Vienna, where there is a panel debate happening. That will also be streamed. There is a link to the stream in the show notes below. So go ahead and follow Sandra further. Thank you so much to all of you. It was the most beautiful and most excellent start of a week one could ever imagine. Thank you. Have a wonderful day.
Thank you so much. Thank you for the invitation.
Thank you.